You're listening to the Patenting for Inventors podcast, part of the Look Legal Pods from the law firm of Nolan Hyman, the #1 source for your intellectual property, business, and entertainment law needs. Now here's your host, registered patent attorney, Adam Diament.
Hello and welcome to the Patenting for Inventors podcast, the podcast where intellectual property law meets real life, one yoga pant at a time. This episode is Lululemon sues Costco, a fashion lawsuit you can't just downward dog out of. I'm your host, Adam Diament, and today we're breaking down a lawsuit that could change how big retailers copy or get inspired by premium fashion brands. We're talking about the 2025 case of Lululemon Athletica v. Costco, filed just this past June. It's a real showdown between the boutique yoga brand that made $120 leggings cool and America's favorite big box wholesaler, where you can walk out with the treadmill, a rotisserie chicken, and apparently some suspiciously familiar activewear. Lululemon is going all in here, alleging design patent infringement, trade dress infringement, trademark infringement, and unfair competition under California state law. This isn't just about one product either. They've called out all the hoodies, jackets, pants, multiple brands across Costco's private label and partner lines. So what's Lululemon claiming? And what will Costco likely argue in response? And who really has the stronger legal stretch? Let's take a closer look. Lululemon claims that Costco is selling blatant knockoffs of its most iconic products. Specifically, they name 6 allegedly infringing garments: the Danskin half-zip pullover and hoodie, the Jockey Ladies yoga jacket, the Spider Women's yoga jacket, the high-tech men's scuba full zip, and the Kirkland 5 pocket performance pants. These are supposedly lookalikes of Lululemon's scuba hoodie, Define jacket, and ABC pants, products that are heavily promoted, widely sold, and closely tied to Lululemon's brand identity. Some of these products, Lululemon says, even use identical color names like Tidewater Teal that are strongly associated with its own line. Now, what makes this more than just a fashion beef is that Lululemon isn't just saying Costco copy their general look. They're saying Costco is infringing design patents, violating registered trademarks, and copying trade dress, the unique look and feel of their garments that consumers recognize as being Lululemon's signature. They're also bringing in California's unfair competition law, which gives them one more way to argue that Costco is unfairly profiting off of the brand reputation. Let's start with the design patents. Lululemon owns 2 design patents here. It's D989442 and D1035219, covering the ornamental look of its scuba hoodie. These protect features like the unique shape of the kangaroo pocket, curved seams, and a specific textured panel layout. Design patents are theoretically powerful. If a competing product looks substantially similar to the patented design in the eyes of an ordinary observer, where the ordinary observer thinks that what they're buying is the same thing shown in the design patent, that's infringement, even without proof of copying. And in this case, Costco's Danskin pullover and hoodie bear a strong resemblance to the patented scuba designs, at least according to the side-by-side images in the complaint. But here's the reality check. Design patent lawsuits in fashion are notoriously difficult to win. Courts often find design elements functional, which isn't protectable, or obvious based on prior designs. What looks unique in an Instagram ad can seem mundane in federal court. Costco will almost certainly argue that any similarities are superficial or dictated by function. They'll also emphasize small differences, different seam curves, different pocket shapes, or branding that might be enough to avoid infringement. They could also argue that the design is anticipated by older garments, especially if they could find similar activewear in the public domain. Anticipated is the legal word that means it already existed before filing a patent application. Lululemon's strength here is the specificity of its design patents and the strong visual similarity in some cases, but its weakness is that courts tend to interpret design patents narrowly, and judges don't always see hoodies the same way fashion editors do. Now, central to Lululemon's case is their claim that Costco infringed on the trade dress of 3 product lines: the Define jacket, the scuba hoodie, and ABC pants. Trade dress refers to the overall look and feel of a product that consumers associate with the specific brand. Think the curved seams on the Define jacket, the distinct back panel of the scuba hoodie, or the gusset layout on the ABC pants. Lululemon argues that these aren't just design choices, they're visual signatures. And it's gone further by actually registering the Defined Jackets trade dress with the United States Patent and Trademark Office, which gives them a stronger legal footing. The challenge with trade dress is always proving distinctiveness. You have to show that consumers associate the designs with your brand specifically. Now, Lululemon does a solid job here. They cite years of use, celebrity endorsements, social media buzz, and a ton of unsolicited media coverage. Another big hurdle is functionality. You can't claim trade dress rights and features that are primarily functional. So even if the curved seam looks cool, if it helps the jacket fit better or makes it easier to sew, it might not be protectable. Lululemon tries to head that off by saying these features actually increase manufacturing complexity and aren't needed for performance, but courts will scrutinize that closely. Costco's likely strategy: attack the distinctiveness and argue functionality. They'll say features like pockets, curved seams, or gussets are commonly expected in activewear. They'll also point out differences in fabric, labeling, or fit. They'll argue that Lululemon's designs are part of broader fashion trends, not unique to them. This part of the case is likely to be the most contentious and the hardest to predict. Trade dress cases can go either way. Lululemon has a strong branding story, but Costco only needs to show that designs are functional or not distinctive enough to avoid liability, or that Costco's designs are slightly different so there's no actual confusion. Now let's talk about classic trademark infringement. Lululemon owns the registered trademark Scuba for hoodies and other apparel. Costco sells a men's product labeled High-Tech Men's Scuba Full Zip, and Lululemon says that's confusingly similar. Here, Lululemon's got a decent shot. If Scuba is widely recognized as a Lululemon brand, then even using the word in a descriptive sense, as Costco likely intended, could be problematic. That said, Scuba could be considered generic or highly descriptive in terms of fashion, often used to describe neoprene-like material, and that ambiguity could give Costco some cover. Then there's the color name Tidewater Teal, which Lululemon says has acquired common law trademark protection. Apparently, some danskin hoodies were sold under that same name. Lululemon claims that Tidewater Teal is distinctive enough to identify its brand, but they've never federally registered it. That makes a harder claim to win. Costco could argue that they had no idea that the color name was protectable or that it was a common industry term, but Lululemon is betting on the accumulation of all these similarities, design, styling, and naming adds up to consumer confusion. Finally, there's California's Unfair Business Practices Act. This law casts a wide net. You don't have to prove design patent infringement or trademark confusion. You just have to show that Costco's conduct is misleading or unfair. And this is where Lululemon's broader narrative comes into play. They cite articles from the New York Times and Washington Post that literally ask, is this a Lululemon dupe? They point to TikTok influencers using hashtag Lululemon dupe and hashtags on Costco products. They say consumers are being misled at the point of sale and after into thinking they're buying something Lululemon related. This is a psychological confusion claim, even if the tags don't say Lululemon, even if the price is different, even if you're buying it next to a 12-pack of tomato sauce, it still creates brand association that Costco allegedly benefits from unfairly. This is probably Lululemon's strongest overall claim because it allows them to blend all their arguments together: design similarity, branding mimicry, marketing language, and consumer perception. Costco will likely respond that they sell under different brand names, use their own marketing channels, and have never claimed any connection to Lululemon. But courts sometimes view this kind of aggregation skeptically, especially when dealing with functional clothing in a crowded marketplace. So who's more likely to win this thing? Lululemon has strong branding, a loyal consumer base, and some registered rights, particularly with the Scuba and Define name and designs. They've taken the time to register trade dress, file design patents, and build a compelling case. They also frame the lawsuit not just as IP enforcement, but as protection against the normalization of knockoffs. Costco, though, has the advantage of ambiguity. They sell under different names, they didn't use Lululemon's logos, and they can argue that most of the features, curved seams, four-way stretch pants, zip-up jackets, are just part of modern activewear trends and aren't exactly the same as the ones on Lululemon's clothing. That might be enough to create legal distance, especially in the eyes of a court wary of turning fashion into monopoly territory. Lululemon's best chance is to emphasize consumer perception, that people see these Costco clothes and think Lululemon. That's powerful, but it's also hard to prove without surveys, testimony, and a judge really understands modern branding. Costco's best defense is functionality, descriptive use, and non-exact reproductions. If they can frame everything they've done as part of a general market trend and not an attempt to mimic one brand specifically, they could skate by. It's hard to call now. It's close, but I'd probably side with Costco for most of the claims. Lululemon has a well-pleaded complaint, but the outcome will likely hinge on how the court interprets consumer confusion and functionality, two areas where fashion law has historically been slippery. Also, winning fashion claims are an uphill battle based on some previous cases. Take Christian Louboutin v. Yves Saint Laurent, the Battle of the Red Shoes. Louboutin claimed its signature scarlet bottoms were being knocked off by Yves Saint Laurent. The court kind of gave them a win, but with an asterisk. Louboutin got trade dress protection only when the red sole contrasted with the rest of the shoe. So Yves Saint Laurent makes an all-red heel, totally fair game. Then there's Abercrombie & Fitch v. American Eagle, the Preppery Showdown. Abercrombie & Fitch basically said, hey, American Eagle is biting our style, but the court wasn't having it. Turns out that khakis and polos just aren't that all unique. And when Coach sued Target over lookalike handbags, the court reminded everyone that being inspired by isn't the same as infringing. Bottom line, unless a brand's look is truly iconic and consumers can spot it blindfolded, judges tend to say, nice try, but trends aren't trademarks. That said, not all hope is lost. There have been wins, like in LA Gear v. Tom McCann, where LA Gear successfully sued over a copycat high-top sneaker. The court agreed that the overall look of the shoe, including things like the molded heel piece, color striping, and placement of design lines, had acquired secondary meaning, which wasn't just functional. That case showed that if a brand builds strong visual identity around a non-functional style, it can protect it, even without a logo. But to be fair, cases where the plaintiff wins is the exception and not the rule. This case just isn't about yoga jackets or pants. It's about how far a brand can go to protect its look and feel in a market saturated with fast fashion and low-cost alternatives. It's about whether the law should prioritize consumer access to cheaper lookalikes or reward the innovation and brand building that premium companies like Lululemon invest in. Win or lose, Lululemon is sending a clear message. If you try to ride our waistband coattails, expect to knock on the courthouse door. Most cases actually don't go to court either, or to the end of trial, so there's a good chance there will be a settlement, even if Costco has the stronger arguments. That's it for today's episode of the Patenting for Inventors podcast. If you enjoyed this deep dive, send it to a friend, post it to your Dupe discussion thread, and tune in next time as we untangle more legal drama at the intersection of innovation, branding, and commerce. And if you need help navigating intellectual property such as patents, trademarks, copyrights, or business matters, give me a call at 424-281-0162. Until next time, I'm Adam Diament, and keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. If you enjoyed the show, please kindly rate and review on your favorite podcast platform. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information about how we can help with your own legal needs, check out our services at nolanhyman.com. That's NOLANHEIMANN.com. Or call Adam Diament directly at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.